A review of copyright, particularly as it relates to education. We have copyright in order to foster creativity for the overall benefit of our society. Please keep this in mind throughout the discussion. This encourages authors to produce new quality works. They gain royalties that further future development. U.S. law protects the original authors no matter their citizenships. Different countries will have different laws. There are three parts, or three clips, for this presentation. The first is the explanation of copyright. The second is the explanation of the fair use defense. And finally, we look at the digital delivery of content. Throughout these sections, please remember that I do encourage questions, but I am not giving legal advice. The goal, model respect for intellectual property, should be our focus as educators. In research, when we use another person's ideas or their intellectual property, we always cite their sources. That doesn't matter if we're summarizing their ideas, paraphrasing, or quoting. The purpose of copyright policy is both a legal and ethical issue. Intellectual property that is not copyrighted may also be protected by trademarks, patent, or trade secret laws. Trademarks can last forever, while patents can last for 20 years. To get the full description of U.S. copyright, check out Title 17 of the U.S. Code and its related laws. Copyright protects the original works of the owner once they are tangibly expressed from being reproduced. It should be noted that derivative works are the property of the original owner. Copyright likely does not protect the idea or the concept, although those might be protected under the patents or trademarks. And it doesn't matter if the work, it also protects any copies or reenactments of that particular piece of work that, again, was original work of the author, tangibly expressed, keeping it from being reproduced. When is something copyrighted? Well, that depends on when it was produced. Today, as soon as it is fixed, or basically it's recorded in some way, shape, or form, it is copyrighted. That means it's made tangible once again. It's fixed in some form. Maybe it's transcribed on paper or on an electronic document, or it's recorded or videotaped. It's important to note the work does not have to be published for it to be copyrighted, and it doesn't need a copyright symbol or have to be registered at the Copyright Office. What is copyrighted? So now you're going to see a full list of items that are copyrighted. And you can see the list goes on and includes many different items. Obviously computer programs, manuscripts, books, but it also includes items in online databases. Obviously musical work, the notes and the words, typically together, but not always. Dramatic works, including any music that accompanies that particular work. Pictures, photos, maps, recordings, and of course computer software. Does it have to be registered with the Copyright Office? in order to be covered by copyright? And the answer, once again, is no. It doesn't have to be registered with the Copyright Office. It is helpful, however, that if somebody is misusing your information, that you register it. It helps with getting damages for misuse. You can do this after the work is created, and hopefully you do it soon enough so that somebody else doesn't try to copyright your work. Otherwise, you have to prove that you're the original owner. Once again, you have to remember why we have copyright, and that's to foster creativity to benefit society, and that creativity will support the authors to a certain extent. So who owns the copyright when the work is done at work? The employer or the employee, or done for work? Typically, it is the employer that is viewed as commissioning the work. And that's true if the work is done at work or at home, as professionals are paid in general for producing and delivering works. It is also true that you can ask to be paid additional money, such as curriculum work, and you get paid for that outside your normal work. But the ownership of the work typically belongs to the employer. Just as with any law, there are civil and or criminal penalties that can be imposed. So the intent is not necessarily is considered, but is not necessary to show a violation of copyright. Ignorance of the law, for example, is not an excuse. Civil law, loss of the profit, obviously, and then there could be statutory damages. It depends on, again, your willful intent in some cases. The criminal cases, 1 to 3 years for more than 1,000, for under 1,000. More than 1,000, and more than 2,500 is 5 years or more. Lawsuits will often help recoup the losses from people who violate copyright. So there are items that are not copyrighted. Works that consist entirely of facts, U.S. government works, works that have expired copyright, we'll go into that in more detail, and works that the copyright holder has given away the rights in writing or in some way acknowledge that, say through Creative Commons is a common method today. It is very important to understand that just because something is publicly available does not mean it is in the public domain and not copyrighted. For example, if you go to the public library and you get a U.S. government piece of work, obviously, since it's not copyrighted, it's U.S. government work that's available to you to use. If you find some other piece of information that is something that is copyrighted, so again, you could use the information if it's properly cited. If you go to Google, for example, again, something that's publicly available. If you go to a government website, there's a very good chance that the images you'll find on the government worksite is publicly available for you to use. Probably still has certain qualifications as far as reuse and republication. If you go to any other site, that work will be copyrighted. You can't just grab a Google image that shows up in Google Images and use that. Now, that needs a little further explanation when we get to the fair use defense, but it should be noted that those works are typically copyrighted. What works have expired copyright and are now in the public domain? This is not typically a very easy thing to explain, as the copyright laws have changed over a period of time. Currently, anything produced before 1923, and of course donated by the author, are in the public domain and available. Anything between 1923 and 1963 that was not registered with the Copyright Office are also available. Anything between 1963 and 89 that was either registered or, not registered, or the person did not put a copyright symbol and the date on it, because during that time period, if they simply put a copyright symbol and the date, that was sufficient to copyright. Now you don't even have to do that. Once again, the author who does not want to constantly give permission for their work often just attaches or puts it forth as something that's free to use, and they might attach a statement to the work, or they might put it in an area such as Creative Commons where they've signed off that says go ahead, use this. Generally, works of interest to students and faculty are not in the public domain, and trying to figure it out can be challenging. Now, if the laws don't change between now and 2019, much of the material that was produced before 1978 will fall into the public domain. So that's an important date to keep in mind, that in 2019, pretty much everything before 1978 will fall into the public domain. Copyright is currently for the life of the author plus 70 years in order for the family of the author to benefit. The first sale doctrine basically says that you can own a copy, or you can have multiple copies, of a book, a song, or movie, but what's important to remember here is that is not the same as owning the copyright. If you own a copy, you are allowed to lend it and to resell that copy that you own. You cannot reproduce it or display it publicly or perform it. So again, owning a copy allows you to lend it and resell that one copy, but it is definitely not the same as having the copyright, which allows you to reproduce or publicly display and perform. So stated another way, the copyright holder has exclusive rights to reproduce and distribute copies, to perform or display works publicly, and to create any derivative works. There are some special rules related to parodies and criticism of using derivative works. So it's not exactly forbidden to use certain works in certain situations. Again, parody and criticism does allow you to use it in some situations. This ends part 1 of the presentation. The second part will be dealing with fair use in a different video clip.